Hey out there, legal warriors. In this video, I'm going to cover the pitfalls and the best practices when serving a response in a restraining order case in Washington State. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and we've also been doing restraining orders, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. What is a restraining order? Well, the technical term is a protection order, but the public usually calls it restraining orders. In Washington State, the protection order statute is under RCW 7.105. And this video is intended for people that have been served with a temporary restraining order. And that means that you've either been emailed a restraining order by the police or by another party. The police have come to your house and knocked on your door and kicked you out of your house, or maybe taken your guns. Who knows what's happened? But you've been served with a restraining order. And usually with that service, you're supposed to get also a petition. A petition is the thing that the petitioner filed. It's their writing that they filed, asking the court to issue, to begin with, a temporary restraining order against you, and then what we call a permanent order. Although a permanent order doesn't necessarily mean it lasts forever. It just means, an order after you've had a chance to respond as the respondent. So usually you get this restraining order and you look at it, and there's a date you're supposed to come to court to tell your side of the story. And if you've watched any of my other videos, you know that the court expects you to file a written response to whatever's in the petition prior to you going to court for the court date to see if the judge wants to issue a permanent restraining order 1 year or more after hearing from both the petitioner and now from you as well. Most people get it right. They understand just in their brain that they have to file their response with the court. And this video isn't about how to file. Is it about what to write in the response, stuff like that? We have some other videos on what that is about, what we need to do when we get served. But this is specifically about when we write out our response, that we don't make the mistake that most people make. Okay, most people know they have to file it with the court, but most people, unless you're in the legal system already or have experience with the civil system, they don't realize that they also have to serve a copy of their response on the petitioner. And if they don't serve a copy of the response on the petitioner, almost always the result at the hearing, because you're trying to get rid of this order, right? There's a hearing in 2 weeks after you get served with the order, somewhere less than 2 weeks. Sometimes it depends how long it took you to get served. And you want your day in court, right? You want to get rid of this order. You want to have your say. And you work hard. You file your response into the court. The court then asks the petitioner, well, do you have a copy of the response? And the petitioner goes, nope. And therefore, the case has to be continued so the petitioner has a chance to reply to your response. And when the case is continued, usually a minimum of 2 weeks, what happens? They continue the order. They reissue the order for another time, and you are still restrained. You're still kicked out of your house. Your guns are still missing. You can't go places. You could get arrested if you violate the order. So it's important that you don't make this mistake. So how do we fix it? Well, we file our stuff with the court, our response, hopefully in a timely manner so the court has a chance to read it. Hopefully at least a couple days ahead of time you need to check and see if there's any court rules that make it be filed sooner for a deadline. But you also have to serve the petitioner. When I say you, I don't mean you. I mean someone on your behalf. Typically speaking, it is not good practice, and some courts might even find it illegal. I don't agree with it, but some courts might, for you to serve your response on the petitioner directly. Now, sometimes the court will be okay with it, but it's safer to have another party who's another person who's 18 years older. I just changed the word from party to person because what a party often means to the court is someone that's named a party. So another person serve the petitioner. So how do we serve the petitioner? Well, the secret is you need to look at the petition. Now, I don't have, each packet's a little bit different, but somewhere on the second or third or fourth page, somewhere in there, it varies depending on which court, there's going to be a spot where the petitioner lists his or her address they can be served at, or hopefully what they've listed is an email address where they can be served at, because that's the easiest thing, the email. So if they have an email listed, then that is the way that is the easiest to get the petitioner your response that you've already filed with the court. So the best practice is to have someone else email the petitioner and then ask for a response that, yes, you've got it. Now, the important thing to remember, and this may sound like legally gobbledygook, okay, is that it's not jurisdictional. We're not talking a petitioner originally serving the respondent with the actual temporary restraining order and petition. That's jurisdictional, so the court can actually issue an order, stuff like that, a permanent order. But it is important. The petitioner just has to get it. We don't have to prove the petitioner got it. We don't need a proof of service, although it's not a bad idea to print out, a copy of what you sent, because when the parties go to court, the respondent and the petitioner, the court's going to say, hey, I've received this from the petitioner. Respondent, do you have it? Yes. Hey, I received this from the respondent. The response, petitioner, do you have it? They're either going to say yes or no. If they've gotten it, they're going to say yes. If they say they haven't gotten it, they're going to get their continuance anyway. So have someone get it to them, hopefully by email. If not by email, you can hire, if there's no email listed and there is a service address, well, then someone else could drive it over there, not you, because you're restrained. Or you could hire a process server to do it. If there's nothing listed, no way to serve them, then you may be stuck. You may have to go to the hearing and say, Judge, there is nothing listed in the petition how I served the petitioner, so here I am. And then let the judge sort it out from there. But the big mistake that people make is they don't serve their response on the petitioner. When I say serve the response, that means serve everything. Whatever you give the court, you have to give a copy to the petitioner so they can be prepared. Likewise, whatever the petitioner gives to the court, they have to give you a copy so you can be prepared. Now, unfair things will happen. Courts can be totally unfair, in my opinion, in some of these hearings because they're so frustrated, right? The petitioner may bring something at the last second, and the court may say, just look at it and not give you a chance to write anything more back, because it's really hard on the court. This is a terrible statute. The legislature is really messed up. I hope you're watching this legislature, because I am not a fan of what you've done here. You've made it very, very easy to use protection orders as weapons, expecting overwhelmed courts to hold the line. And that's not what's happening in practice, because it's just too hard. There's too many of them. So this video is not about changing the law, though I hope it changes. It's about trying to speed up the process. If you're a respondent, remember, you need to serve the petitioner. If you're a petitioner watching this and you're going to serve a reply, that's your answer to the response. You've also got to do the same thing. And if you got to that first hearing, the court is going to have thought ahead and thought about how the respondent can be served by the petitioner any replies or additional materials. And that should have been covered on the record at the first hearing, likely when it gets continued for you to file a reply. Obviously, you could likely also reply in the same way you got served. If the respondent sent you an email, you could probably send one back. But you want to reach out to your coordinator, to your court, or hopefully get an attorney so they can tell you how best to do it. These are just examples, not legal advice. But I think it will go a lot smoother if we realize that everybody needs to get everything that the court has. Otherwise, it's not fair to anybody. So I hope you found this useful. If so, please like it. Please subscribe. More people will get to see it. And more importantly, if you're needing a restraining order, if you're fighting a restraining order, a protection order in Washington State, feel free to give my office a call. We've been doing this for a long time now. We're pretty good at it. And if we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.